Hi, this is Professor Higgins, and welcome to Business Organizations here at Valencia College. Today, we're going to be focusing on corporate formation here in the state of Florida. We're discussing how to form a corporation. I've provided notes for you in your modules, and so I'm not going to read the notes to you again, but I do want you to use them as we go through this discussion and to add additional notes into your own, into the notes that I've provided for you. We're going to talk about the first thing that, as paralegals, is especially important is pre-incorporation and the pre-incorporation matters that you have to deal with before you can form the corporation. Every paralegal or every law firm will have a corporate information form, and that's the form that the paralegal sits down with the client and goes through, and it has all the questions that you want to ask and find out about the client so that you can produce these forms appropriately and fill them out correctly. So the first thing that you're going to do is obviously gather client information, the information that you're going to need to incorporate. This is generally done by the paralegal, and you're sitting down with the client and you're just getting all of the general information with the form. The next thing that they're going to do is choose a domicile. And I have put in the notes some people historically have liked Delaware because there were a lot of advantages to incorporating in Delaware. But now Florida is a great choice, and there's really no reason why someone wouldn't choose to incorporate here in the state of Florida. Our laws are very amenable to corporations, and if you are planning to conduct business here in the state of Florida, then it would behoove you to make Florida your place of incorporation. So first, you have your client choose the domicile. Then the next thing they're going to do is decide on corporate structure. Are they going to be a C corporation or an S corporation? Are they going to be a professional association, meaning that all the shareholders of the corporation are going to be of the same profession? Or are they going to be a nonprofit? And we will see that nonprofit corporations can be extremely profitable. They can be very profitable. The next thing, after we decide on the corporate structure, whether they're going to be an S or a C, and if they don't select one, then the state of Florida just decides that they're a C, so they need to make that decision. Next, the promoter. Who is the promoter of the corporation? The promoter is the person who is promoting and getting the corporation to the place of incorporation. And generally, the promoter is an owner or will be an owner of the corporation, but it doesn't always have to be. Sometimes it's just someone who's really good at getting things together and very organized, and is someone that the to-be corporation has asked to bring them up to be a corporation. They are the ones that begin creating, projecting, and organizing the corporation. All of the pre-incorporation transactions include things like any transaction made by a promoter on behalf of the corporation before the actual incorporation. An important thing to note here about the promoter is going to be entering into contracts with, let's say, the phone company or the utility company, or renting space, or purchasing computers. And these types of things, when they enter into a contract, if they're not careful, they can be personally liable for these contracts. So it is important for the promoter to let whoever they are entering into a contract know that they are doing so on behalf of a corporation. And once that corporation is formed, there's something called the ratification of pre incorporation transactions. And that is essential to protect the promoter from being personally liable. So once the corporation becomes a corporation, they will ratify all of these contracts, and then they will take over. There is a Florida statute, and it is 607.0204, that says promoters are liable if the person with whom they are dealing don't know that there is no corporation. So if someone is going out and they are entering into contracts, and the person on the other side believes that there's already a corporation in existence and they're doing it on behalf of that corporation, the promoter is going to be liable. They are required by Florida statute to let the other party know that I am merely a promoter, we are starting a corporation, and once the corporation is in fact alive, or once it becomes effective, then your contract will be with that corporation, not with me. Okay. Another thing that is done to form a corporation is to enter into a pre-incorporation agreement. That's an agreement between all the potential and new shareholders regarding the terms of the formation. It will address the content of the articles and the bylaws, as well as identify and set forth the terms of the initial board of directors and who they want to be the registered agent. Now, this pre-incorporation agreement, although it sounds very important, is optional. It's not always done, and I would say probably 50% of the time they have a pre-incorporation agreement, although it is extremely helpful and should be. I think if there are attorneys that are involved, then there should be, and a paralegal, you should draft up a pre-incorporation agreement for the shareholders to sign. There is also another agreement, a stock subscription agreement. This is also optional. And the reason that there's a stock subscription agreement is to make sure that by selling these stocks, people are agreeing to buy these stocks once the corporation comes into existence, that there will be enough money to get this thing off the ground, to get it rolling, to provide that initial capital for the corporation. So once the stock subscription agreement is entered into, you will now know that you have the money that you'll need to start up the corporation. This is also optional. It's not mandated by any statute, but it is a very, very good idea. There is a Florida statute here as well that speaks to this. A subscription for shares entered into before incorporation is irrevocable for 6 months unless the stock subscription agreement says differently. If it says otherwise, then they're on the hook for as long as the agreement is. But if the shareholders enter into a subscription agreement where they agree to buy 10 shares of stock at a certain price, they're going to be held to that for 6 months. For 6 months, it's not revocable, because by that time they should have the corporation up and running. If they don't, well, then they're not on the hook anymore. Okay, the procedures for starting up a corporation. The first thing that you're going to do under Chapter 607, which is our Florida corporate statutes, is you're going to select a name. It must be a unique name, because unlike any of the other business entities that we've studied so far, you cannot have the same name as someone else. So select your name and look it up and make sure that it doesn't belong to someone else before you start printing cards and start printing the name on things. Research whether it's available. Your name must be distinguishable from all other entities whose names are on file with the Division of Corporations. There are several places that you can check. The first one absolutely is sunbiz.org. You want to go and do a corporate name search. You'll look for all the active and all the inactive corporations. So you don't want to select a corporation with a name that's similar to an inactive corporation, or like we discussed in our earlier business entities, those creditors might come looking for that old corporation and find you instead, and then you might get embroiled in some litigation that you're going to have to get yourself out of. You can also do a fictitious name search just to make sure that no one is using that name on that you want to use. You generally don't have to file for a fictitious name, but it's a good database of names which to look for to make sure that you are not replicating anything. The other one that is really good to look for is the United States Patent and Trademark Office. And I've put the website there. Go there and make sure that the name that you've chosen is not being used under the U.S. Patent and Trademark Office, because if it's not that anything bad's going to happen to you, it's just that if you go to all the work to create this corporation and you have your name, when you actually file for and become a corporation, if your name is already in use, they just deny you. And so you have all of this work done. You have to start all over and reprint all of this stuff. So check and make sure that you are not replicating another name. And then miscellaneous places, I have some listed here: official records in the county courthouse, online phone books, Google or Yahoo searches, switchboard.com. Just any other additional places that you check. The more research you do, the more you check to make sure that your name is not being utilized, the safer you are. Are there any name restrictions in Florida? Yes, there are. In the state of Florida, if you form a corporation, you have to have incorporated or company or their abbreviations in the name, because if you don't specify in the name of your corporation that you are an actual corporation, you may be held personally liable, or your shareholders will be held personally liable. So make sure that that is in your name. And then there's a list of forbidden names. You can read about this under the procedures for starting up a corporation. And there's things like articles of speech don't count. The use of periods doesn't count to set you apart and give you a different name. The list goes on and on. So I want you to see the regulation. If you try to incorporate with a name that's already being used, then the Secretary of State will reject your incorporation and send you names and addresses of those similar corporations. So just do your homework and make sure that you don't use somebody else's name. All right. The fourth thing, if necessary, file for a fictitious name. It's usually not done. Usually corporations, because they're already filing as incorporated or company, it's only done when maybe a corporation wants to do business as several different smaller businesses, and then you may have fictitious names. But for what our purposes are, and for just talking about general corporation law, you don't need to file for a fictitious name. Okay. Another thing that the paralegal will do is prepare and file the articles of incorporation with the Florida Secretary of State. Sometimes this is called the charter. The articles of incorporation are the articles that are actually forming the corporation. Florida law requires the following things to be included in the articles of incorporation. I'm going to give you a hint here. Keep it very simple. For all of the things that Florida asks for, do not get verbose and be very descriptive. Just clean and simple, short answers, as short as possible. And remember, the public has access to this, so you don't want to give information that is confidential for any reason. The effective date of the corporation, when it's going to start, the name of the corporation, the address of the corporation, the number of shares of stock in the corporation, or that the corporation is authored to eventually issue. And on this one, I say go big. You can plan maybe only to issue 10 shares of stock because you're going to have 5 shareholders and everybody's going to have 2. But who knows? If the company starts growing, I would suggest 10,000, authorize up to 10,000 shares of stock. And that way, if you do decide rather than 10, you want to have 25 or you want to go to 100 or 1,000, that you can do that without having to amend your articles of incorporation, because that's kind of a big, hairy deal and costly every time you do it. Let's see, what else do I need to tell you about that? And this is, again, about preemptive rights. Wait, I don't think I mentioned that at all first. Okay, so if you have shareholders and they each originally have a certain amount of shares, then if the shareholders are no longer to be given preemptive rights to acquire shares issued subsequently by the corporation, a provision setting forth the extent to such rights must be included. If not, the shareholders have no preemptive rights. What all this means is that when you are starting a corporation and everybody gets their shares, let's say we're going to start a corporation and let's say there's 5 of us. Well, I want to hold 51% of the shares because I want to have the controlling vote. So I want to be able to always be able to boss everybody around and kind of bully my way around in the corporation. So the other 4 of you have 10, let's say there's 5 of you, because I'm not good at math. So each one of you has 10%. Except for the 5th one of you has 9%, and I have 51% of the shares. Now, as we go on, and you guys are fine with that because I'm having to put in more money or whatever. As the corporation goes along, what you have to have in, I believe it's in the Articles of Incorporation, if you want to give the current shareholders preemptive rights, then you have to put that in your Articles of Incorporation. And what that means is that the individuals, however many, if I have 51% of the current shares that are out there, and let's say they are going to release 100 new shares, I have the right of first refusal for 51 of those 100 shares because I get the opportunity to keep my standing. If you have 10% of the shares, then you have a preemptive right or right of first refusal to buy 10 of the 100 shares that are coming out. However, if I don't want to buy 51 of them, I don't have to. It just means that I get the right to say no. All right, let's move along. The other thing that you have to have, just like any other business entity, is a registered agent. So the name of the registered agent and the address of the registered office have to be attached. Remember to attach the acceptance where the registered agent is agreeing to it. Yes, it's usually an officer of the corporation or an attorney. The name and address of the incorporator. Now remember, the incorporator can be a shareholder or it can be anyone. The person who is going to sign the Articles of Incorporation is the incorporator. And they don't even have to be someone who has a future interest in the corporation. Okay, duration has to be established. Because if it's not, if you don't say how long you want your corporation to exist, then it is going to be in perpetual existence. It's going to just be assumed that this corporation is going to go on forever. 8 is special edition for professional associations. Okay, if you are forming a corporation for a bunch of professionals and they are all going to be shareholders, the purpose of the corporation must be stated and it must be limited to the practice of that said profession. It must also contain professional association in the name, or PA, or the word chartered. And when you see chartered, that means you have a professional association, which is a corporation. Okay, then it is signed. The articles of incorporation are signed by the incorporator and dated. There's no notary that's needed. You file the articles of incorporation, the acceptance of the registered agent, and you pay the fees. Here I've put the Division of Corporations, Department of State in Tallahassee. That's where you're going to mail all this. And if you do mail it, they will actually make a copy of it and date stamp it and send it back to you. So you have proof of the corporation and you can go use that for any of your banking needs. Otherwise, if you just do it online, which I'm sure is fine, especially now after COVID, you will have the proper credentials to go ahead and do any bank work too. But just in the old days, we like to have that piece of paper and we like to have it date stamped by the Secretary of State. Okay, that's it. To form a corporation, it cost $70. $70 is pretty darn cheap to start a corporation. Corporations are very cheap to start. Here in the state of Florida, there's a $35 filing fee, and then there's a $35 fee for designating your registered agent. If you need any certified copies, which you generally don't, and I don't feel like you have to do that unless you just want them for some reason, it's unnecessary, but you can get them. And then after you send this off, it takes about 2 weeks to be returned. Now, if you make a mistake in your articles of incorporation, you have 10 days to correct that mistake. After 10 days, it's going to be a pain in the neck. So after the 10-day window, if you've noticed you have a mistake, you file articles of amendment to the articles of incorporation. So just don't make any mistakes, or find them within the 10 days. Keep looking. And then there's going to be a fee for that. And it may be as much as the initial filing, but you're going to have to look up that fee. Okay. Then the textbook talks about creating a shareholder agreement. This is something that the paralegal would probably do. And I have gone through and listed, if there's more than 2 shareholders, you need to spell out their rights and obligations. And so I have listed 9 of them here that you would go through and make sure you hit all of those in your shareholder agreement. Remember, the shareholder agreement is optional, but a good idea. Okay, and then, let me say, Section 607.0731 and 607.0732 of the Florida statutes states or mandates that if there is a shareholder agreement, it must be noted on the stock certificates in order to bind future transferees of the stock. So once you buy the stock, if there's a shareholder agreement, you need to be able to see that on your stock, so that you can go take a look at that agreement and see if you agree to it. All right, now here the next item is the organizational paperwork, and that's going to be put into a corporate notebook. Paralegals do this, so this is something you want to pay very close attention to. The first thing that you're going to put in the corporate notebook are the bylaws. You take a look at section 607.0206 of the Florida statutes. These are the rules that regulate the organization and operation of the corporate notebook and the corporation. Everything in your corporate notebook must comport with Florida law. So every corporation is required to have a corporate notebook. there are form bylaws that you can purchase, or you can look up online, but the scary thing is they may or may not comport with Florida law. So generally, if you're working in a law firm that does this type of thing, they are going to have form bylaws, and then you will take that information chart that you sat down with the client, and you will customize this form given all of the parameters that your client has given you. Okay, the bylaws may contain any provision for management of the business and regulate the affairs of the corporation so that it's not inconsistent with Florida law or the Articles of Incorporation. Now remember, the Articles of Incorporation are the documents used, or they are the procedures that we have to form or create the corporation. The bylaws are going to be the law of the corporation. So that's going to regulate how business is done and how everything operates within the corporation. They have to be very, very comprehensive. Okay, after the bylaws, you are going to have a waiver of notice. And what a waiver of notice is, it's critical. It's very important to have the waiver of notice because Florida statute requires that anytime you have any type of meeting at all shareholders have to be noticed. They have to be told about it, so that they can attend it. Well, getting notice to all of these shareholders, if you have 25 or 30 or even 100, it's not that expensive and time consuming. But if you have hundreds of thousands, as some corporations do here in the state of Florida, then that is going to be extremely time consuming and extremely expensive. So what you can't get is when someone is a shareholder, you must get a waiver of notice from them. And that way, if you don't give them notice for some reason, then the corporate veil cannot be pierced. It's really protecting the corporation. The law sets strict mandates about the timing and the procedures for notice, and for hearing back from them. So what you want to do is, as a paralegal, you want to have all the shareholders and all of the directors sign the waiver of notice, and then you want to keep it in this corporate notebook. The funny thing is about this document, the waiver of notice, you can sign that before you have a meeting. It can be signed during the meeting. It can be signed after the meeting. Maybe there was a meeting that you weren't given notice to. It's come and gone, and you never got notice. You can waive that notice even after the thing has occurred. So it will protect. It's a big protection for the other side not to be able to pierce the corporate veil and have the shareholders all be personally liable. All right, the third thing that we're going to put in this corporate notebook are the minutes of all the meetings that occur. According to Florida law, minutes must be kept of all the meetings of shareholders and of all the meetings of the board of directors. So the first meeting that they have, the paralegal will type up the minutes, and in that first meeting, they have to determine the officers and the directors. They get elected and appointed and hired. They have to adopt the bylaws, the corporate seal, which must have the word seal on it, and stock certificates, and then any other organizational decisions that were made. The paralegal types all of this up, and then it is signed by the president and the secretary of the corporation that were just elected that day or hired that day. Okay, the fourth thing is the resolutions. When the board of directors or shareholders make a major decision, it's usually done in the form of a resolution. We hereby resolve A, B, and C. Important resolutions have to go into the corporate notebook. Um, and usually, at the organizational meetings, they're making resolutions such as they're going to choose a bank, which would be the banking resolution. They're going to adopt S corporation status or C corporation status. They are going to ratify, remember that preemptive transaction, um, all of those contracts. They're going to do a ratification of preemptive, or not preemptive, pre incorporation transactions. I think I just got um, stopped. I don't think we're recording anymore, so